Hey everyone, welcome to Amrita IAS Academy. My name is Sibi Joy and as part of our UPSC Civil Services examination preparation, in this video, we will be discussing the polity questions of the Civil Services Preliminary Examination of 2021. So, while going through this video, we will be learning not only the concept behind it, but also the logic and the intuition behind it. Also, we will be addressing all the questions with regards to polity, and this will give you more information with regards to how you can attempt the answer and also the concept clarity with regards to this question. So, without any delay, we will go for the first question. The first question is, we adopted the parliamentary democracy based on the British model, but how does our model differ from that model? So, the question is the difference of the Indian model from the British model, especially the model of parliamentary democracy. So, let's take the first statement. As regards legislation, the British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. Whereas in the second statement, in India, the matters related to the constitutionality of the amendment of an act of the Parliament are referred to the Constitution bench by the Supreme Court. Select the correct answer using the code given below. 1 only, 2 only, both 1 and 2, neither 1 nor 2. So, they are saying, with regards to legislation, the British Parliament is supreme or sovereign, but in India, the power of the Parliament to legislate is limited. Why? In British or in Britain, they have a unitary form of government. They also have an unwritten constitution. So, you will be learning about this in the basics of polity, that they have in this the Parliament is supreme. But whereas in India, it's not like that. In India has a federal structure. We have a written constitution, and here the constitution is supreme. Here the Parliament is supreme. So, taking this into account, I can say, yes, the Indian parliamentary system is limited. Yes, the power of the Parliament to legislate is limited. It is limited with the constitution, but also apart from that, it is also limited by the doctrine of basic structure. We can't amend everything. We can't amend everything. We can't change everything. No, there is a judicial innovation by the name of doctrine of basic structure, which prevents this from being, which prevents the Parliament from changing the constitution without any restraint. So, we have something known as the doctrine of basic structure, and all this shows that there is the power of the Parliament to legislate on the constitution or with regards to the constitution is limited in certain scenarios. So, the first statement is right. The second statement, in India, matters related to the constitutionality of the amendment of an act of the Parliament are referred to the constitution bench by the Supreme Court. Yes, the second statement is right. With regards to the constitutionality of the amendment or an act, we have the Supreme Court does have the power to refer it to a constitution bench, and this power is present mainly for the Indian Supreme Court. I think India is the only country which has this power. India is one of the, therefore the Supreme Court in our country is highly valued when you compare it with the Supreme Court of the other countries. So, the second statement is also right. In this case, the answer is option C. Okay, we'll go for next question. With reference to the union government, consider the following statements. Gopalaswamy Iyenger Committee suggested that a minister and a secretary be designated solely for the pursuing the subject of administrative reform and promoting it. The second, in 1970, the Department of Personnel was constituted on the recommendation of the Administrative Reforms Commission, 1966, and this was placed under the Prime Minister's charge. Which of the statements given above are correct? Option A, 1 only, option B, 1 or 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. So, Gopalaswamy Iyenger Committee suggested that a minister and secretary be designated solely. No, it's a factual question. It was not the Gopalaswamy Iyenger Committee, but rather it was the first ARC. So, we learnt about the second ARC recommendation. So, that was the first ARC recommendation, the first Administrative Reforms Commission, which recommended that a minister and secretary be placed separately for designated solely for pursuing the subject of administrative reform and promoting it. That was a recommendation. And in 1970, the Department of Personnel was constituted on the recommendation of the Administrative Reforms Commission. Yeah, yes. And this was placed under the Prime Minister's charge. No, it was not the Prime Minister's charge. It was under the charge of the Cabinet. Under the Cabinet, not the Prime Minister as such. It was under the charge of the Cabinet. So, taking that into account, I can say this statement is wrong because it's not the PM, and this statement is wrong because it is not the Gopalaswamy Iyenger Committee. It is rather the first ARC. So, taking this into account, I can say both the statements are wrong. Therefore, the answer for this question is option D, neither 1 or 2. Okay. I hope it is clear for this question. We'll go for the next question. This is the third question with regards to the polity subject. Right to privacy is protected under article or under which article of the Constitution? Article 15, Article 19, Article 21, Article 29. Obviously, having a basic understanding, this is a question which has already been asked. It's a PYQ question. It's a PYQ question. Apart from that, this is also a question which is purely conceptual, and this is something which is easily understood if one understands the fundamental rights. If you look at the fundamental rights present over here, Article 15 comes under right to equality. Article 19, freedom, right to freedom. This also comes under right to freedom. So, we can say that it's not Article A, it's not Article D. So, we will remove this. Now, it comes under mainly right to privacy comes under right to freedom. So, knowing this, Article 19 and Article 21. The very famous case of Puttaswamy emphasized the role of right to privacy, and this has been placed under Article 21. So, the Puttaswamy case is with regards to Article 21, which is right to privacy. Therefore, the answer for this question is option C, Article 21. Right to privacy is protected under which article of the Constitution? It is Article 21. So, we will discuss the fourth question. Consider the following statements. 1. In India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies or contesting in 3 constituencies. Second, in 1991 Lok Sabha election, Shri Devi Lal contested from 3 Lok Sabha constituencies. 3. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of him or her winning in all the constituencies. Which of the statements given above are correct? Option A 1 only, option B 2 only, option C 1 and 3, and option D 2 and 3. So, in this case, the first statement, in India, there is no law restricting the candidates from contesting in one Lok Sabha election from 3 constituencies. No, there is a law. RPA, Representation of People's Act of 1951, prevents or does not allow a person from contesting for a Lok Sabha election in more than 2 constituencies. They can contest in only just 2 constituencies, not more than that. But this amendment was brought in at the late 90s. It was brought in the late 90s. I believe it's 96 or 90. It was brought in the late 90s. Okay. So, you go back to the previous question. Is there a law? Yes, there is law. So, you can say that this statement is wrong. Removes option 1. We are left with 2 options. Option A is gone. Option C is gone. Now, we are left with 2 options. Option B 2 only and option D 2 and 3. So, automatically option 2 becomes right. Let's look at the third statement. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-election to the constituencies vacated by him or her in the event of him or her winning in all the constituencies. Yes or no, if you look at it, no. Presently, no. Because this is a electoral reform. This is an electoral reform which is being suggested right now. Okay, so it hasn't been into law presently, or if it has, there's not much clarity into it as such. So we can say when this question was framed, the candidate, no, there is no rule as such. So there is no existing rule as such. So this is a probable reform. So the third statement is also wrong. Keeping that into account, we can say the answer is option B, 2 only. The answer is option B, 2 only. Why? Because there is a law, RPA 1951, and this is not yet brought into action. So answer is option B. I hope you all understood with regards to this question. Question number 5. With reference to India, consider the following statements. Judicial custody means an accused in the custody of the concerned magistrate, and such accused is locked up in police station, not in jail. The second statement says, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Which of the statements given above are correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. So looking at this question, let's talk about judicial custody. So we are familiar with the term judicial custody, and that is also police custody. So when you look at it, there are two kinds: judicial custody, police custody. When you are under the custody of the police, when you are placed in the police station, that is what we say as police custody. When you are put in jail, that is known as judicial custody. Okay? Judicial custody means an accused is in the custody of the concerned magistrate. Yes, that is right. And such accused is locked up in the police station, not in jail. No, no, no. If that person is, or if that accused is locked up in police station, that is not a judicial custody, but rather it is a police custody. The police can keep a person in jail for 24 hours, before they produce this person to the magistrate, they can keep that person in police custody. But once the person has been shown in the court and the judge has given the decision, he or she is transferred to the judicial custody, and that is where we put them in the jail. So this statement is wrong, but rather it should be the opposite. The accused is locked up in jail and not in the police station. So the first statement is wrong. Second statement, during judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Yes, that is right. The police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. That is absolutely true. The second statement is right. Keeping this into account, I can say the first statement is wrong. Both 1 and 2 is wrong. So the answer is option B, 2 only, with regards to question number 5. Okay. So we'll go for the next question. Coming to question number 6. With reference to India, consider the following statements. When a prisoner makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. 2. State governments have their own prisoners' release on parole rules. Which of the statements given above are correct? Option A, 1 only, option B, 2 only, option C, both 1 and 2, and option D, neither 1 nor 2. So looking at this, what is a parole? When a person makes out a sufficient case, parole cannot be denied to such prisoner because it becomes a matter of his or her right. Parole is not a right. Parole is not a right. In the Bombay High Court judgment, they clearly said parole is based on different factors and it's a discretionary power. Okay, it is not given as a right, but rather because of good behavior, it is allowed or granted. It is allowed or granted based upon certain behavior like good qualities, good characteristic, good behavior, they give it. It is not a matter of right which you can demand. So keeping this into account, I can say parole is not a right. So the first statement itself is wrong. The second statement, state governments have their own prisoners release on parole rules. Yes, state governments do have it, because this comes under the state custody 2 compared to the only the union list. So it's a part of the concurrent list, if I'm not mistaken. Looking at this, I can say that this state does have control over the parole rules. Why? Because the state government has its own authority over the local law and order and police, so they can grant their own parole, and that is under the custody of the state government. So the state governments have their own personal prisoners release on parole rules, which is also there for the central government too. So keeping this into account, I can say the second statement is right, the first statement is wrong. Again, the answer is option B, 2 only. Okay. We'll go for the next question. Question number 7. At the national level, which ministry is the nodal agency? Which ministry is the nodal agency to ensure effective implementation of Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act of 2006? Ministry of Environment, Forest and Climate Change, Ministry of Panchayati Raj, Ministry of Rural Development, and Ministry of Tribal Affairs. So this is a factual question. It is a B, C, D type question. There is no statement to eliminate. There is no point you can pick out and choose and say like this is wrong and this is right. Let's look at what is there inside the question. Then from that we can go. So it generally talks about implementation of Scheduled Tribe and Other Forest Dwellers Act, Traditional Forest Dwellers Act, Recognition of Forest Rights Act 2006. So forest is here. So maybe we can keep this. Panchayati Raj, not very clear, so let's leave it as that. Ministry of Rural Development, leave it. Ministry of Tribal Affairs, yes. So we can say these two are the major ones which have some relation with this. But is this about the environment that we are talking about? Is it about the environment? No. In this question, it is not about the environment. It is about the rights of the scheduled tribes and traditional forest dwellers. The rights they possess over the land in which they have been living for decades, centuries, even millennium. So this is talking about those rights. So it is not about a matter of environmental protection, but rather it is about the rights being given to tribals. So the answer for this question is option D, Ministry of Tribal Affairs. Okay. So that is the answer for question number 7. Let's go for question number 8. And legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of the application of law violates which one of the following articles of the Constitution of India? It's a mighty difficult statement to comprehend in one shot, but let's take out the keywords and then understand. It's a legislation, so it's a law. It's a law which confers on the executive. That is, this law gives the executive or the administrative authority a kind of discretionary power. What kind of discretionary power? Unguided and uncontrolled discretionary power. This law gives the executive unguided, undiscretionary power in the matter of what? In application of law. That is, while applying law, they can do whatever they wish. It is not necessary that they have to say that the law is applicable for all, the law is applicable to scheduled tribes, this law is applicable to scheduled caste, nothing doing. This law is applicable to women, this law is applicable to children. No, they can do whatever they wish without any sanction, and that in the matter, that is what they say. Uncontrolled discretionary power in the matter of application of law violates which one of the articles of the Constitution. So for that, you need to know the articles. So simply said, you need to know what are these articles. So keeping this in mind, this idea where power is given so much, that they can have a, a very biased interpretation. They can decide who comes under this law, who doesn't come under this law. A very unguided thing goes against the basic concept of rule of law. Rule of law comes under specifically Article 14. Specifically Article 14. So this is a basic fundamental question. It is talking about rule of law. Article 14, right to equality. Your answer is set. It is talking about a power being given to the executive or the administration so much that they have unguided, uncontrolled discretionary power with regards to applying laws with regards to application of law. So it is a violation. Yes, it is a violation. Which violation is it? It is a violation of rule of law. It comes under Article 40. Clear?
Amrita IAS Academy.